Yeah. All right. Good morning. Welcome to this edition of Sterling Seacrest Pritchard University. My name is Doug Reeder, and I'm executive chairman and one of the founders of Sterling Seacrest Pritchard. For those who don't know us well, because I know we have, I think, a few new people on the call, which is great, and we're very happy about that. We are one of the largest privately held independent insurance brokers in the southeastern U.S. We work in partnership with our clients and community to provide services, solutions, and support customized to today's dynamic marketplace. Our firm has a client-first philosophy and robust resource platform delivered by almost 300 colleagues across 8 offices in the Southeast. One of our key differentiators is the deep industry verticals with dedicated teams, including healthcare, construction, real estate and hospitality, transportation, logistics, nonprofits, and private client risks, meaning personal insurance. We also have a large benefits consulting practice, which is industry agnostic. We're broker owned and have a common long-term perspective and a commitment to educating and informing our clients and friends, which is manifested in today's program. I would like to thank everyone for joining us. We've been doing these programs consistently for 8 years now, because we literally celebrated 8 years in this building, I think, this past few days. And we really appreciate the regular attendees and also the new folks who occasionally jump on, and folks who come back, once a quarter or twice a year. We're just really glad to see the acceptance we've got among our clients and friends of the firm. We are very excited to have Shannon Dennis today with Safety Consultants USA here to tell us about OSHA's top 10 citations and strategies and tips you can use to manage compliance. Shannon is a senior safety specialist and training development manager for Safety Consultants USA. She has over 20 years of experience in the safety field, working with both manufacturing and construction clients. I think we have a number of each on the call. Shannon is also an OSHA outreach trainer for construction, general industry, and an MSHA approved trainer for surface mining. She holds a safety trained supervisor for construction, STSC designation from the Board of Certified Safety Professionals, and has completed the general industry certificate program from the University of Alabama. Shannon also completed her bachelor's degree in operations management at the University of Alabama, Birmingham. Please join me in welcoming Shannon Dennis.
Good afternoon, everyone. Good with them. Okay. All right, so we're just going to dive right in. Thank you for having me. Okay. All right. So we're going to talk a little bit about who OSHA is first, and then into what the top 10 citations are. The top 10 citations change a little bit every year, but not very much. So you can pretty much expect, as we're nearing the end of the year, that next year's will be very similar to what we see here. So the things that we will go through is, one, who is OSHA and what is their job? What to expect from OSHA in 2021. This is a little outdated at this point, but we'll see if we've seen some of these things. We'll talk about how to handle an OSHA inspection, how to effectively interact with the compliance officers, and again, learning ways to avoid the top 10 citations for your facilities. So first off, who is OSHA? OSHA is the Occupational Safety and Health Administration. They are part of the Department of Labor, and 27 states have state plan states, but they are all at least as stringent as the federal OSHA program. Anyone that has employees is covered by OSHA. All right, so OSHA was established in 1971 with the purpose of protecting who? The American worker, right? Their mission statement, as stated here, is to ensure the safe and helpful working conditions for all working men and women by setting and enforcing standards, by providing training, outreach, education, and assistance. And depending on who's in charge with the OSHA administration, their focus will change a little bit from penalty-driven situations to more of a assistance driven administration. So we see those at different times as well. There are different standards. The standards for OSHA are divided into two main categories. Most of them fall under 1910, which is general industry, and that covers everybody that's not construction. Construction is 1926. There are also some some smaller standards for maritime and also agriculture. Under the construction standards, you'll see things like fall protection, trenching and excavation, two of the biggest hazards, two of the main ways that people lose their lives in the construction industry. Confined space, fire prevention, electrical safety. There's all very specific 1926 standards for those. On the general industry side, you will have some standards that are considered horizontal standards that cover both industries. So the two examples I have here, respiratory protection is a 1910 general industry standard, but it also covers the construction industry. The vertical standards would be the ones that apply specifically to the industry that you're in. All right. When there is not a specific standard that covers a topic, OSHA can and will cite under what is called the General Duty Clause. This is Section 5A1C of the OSH Act. And basically what the General Duty Clause says is that if you recognize an unsafe condition and it's recognized by your industry or you as an employer, and it is something that is likely to cause death, or serious harm, and you have not made any efforts to minimize this hazard or address it, then you can be cited under the General Duty Clause. Again, it can't just be handed out randomly. That you have to, OSHA has to burden of proof to be able to prove that that a known hazard was there, that it did exist. But sometimes it's cited in areas where there is not a specific standard that has been promulgated. A good example of that would be ergonomics, where there is not a specific standard that has been passed for that. Right. Some of the things that we have to do for OSHA, if we have 10 or more employees, we fall under the record keeping standards. With the record keeping standards, that's in 1904 is where you can find that in the regulations, and it requires that we must record any workplace injuries within 7 days, any workplace injuries that meet the record keeping requirements. And we need to post that 300A electronically by March 2nd of every year through the electronic record keeping requirements. We need to post this annually from February to April where our employees can see it. Again, it must be updated within 7 days after a recordable incident. And one of the things that you need to do at your facility is be able to produce at least 5 years of these records. Typically in an OSHA inspection, if they were to come through, they'll typically ask for the past 3 years to review. And why is that important to them? Because even as a safety consultant, that's one of the things that we will typically ask to see of a new client, because it lets us see what type of injuries you're having in your facility. It also lets you know for that 5A1 General Duty Clause, if they see multiple injuries in your facility over the past 5 years, then lets them know that that was a known hazard in your facility, even if it is not something that's specifically addressed in an OSHA standard. Again, you need to be able to produce these in a reasonable amount of time. So if they're kept, if somebody has to go back to a database or pull them out of a file, we need to be able to get to that in a reasonable amount of time. So what are some examples of recordable injuries? Again, this can be a good half-day topic. Start really digging into it deeply, but some of the main ones, a fatality. A fatality must be reported to OSHA within 8 hours of the event. If for recordability, anything that requires days away from work, so where someone cannot perform their normal job duties. Restricted duty, again, would be I can come to work, but I'm not able to perform my full functions. Maybe I can only lift 10 pounds or something like that. And it's a good idea to have some restricted jobs available so that people aren't sitting at home watching commercials and things like that. So you want to have some defined jobs for that. Other things that can be recordable: hearing loss. If anytime anyone's prescribed a medication, no matter what the injury, becomes an OSHA recordable. Loss of consciousness, anything, treatment above and beyond first aid, as well as some illnesses. And again, COVID is one of the things that in the medical profession, especially, where could be potential OSHA recordables as well. Other things that we think about for, again, for OSHA compliance and things that from our record keeping, what we can pull is our total incident rates. Total incident rates are calculated based on the formula that you see here. And so it's your total number of recordables times 200,000 divided by your number of employee labor hours. If you work in an industry where you use subcontractors, or you are a subcontractor working for somebody, this is important to you because it's a way to judge somebody's safety performance. It is a lagging indicator of safety because it's based on past performance, but it is one of the only ways we have to judge people's safety performance. Is it a fair indication of a safety record? Not necessarily, because you see, depending on the number of employees somebody has. If I'm a small employer with 50 employees, that number that I'm dividing by is going to be relatively small compared to an employer that may have hundreds of employees. And so it's not always, it shouldn't be the only thing that people use to compare, but you should be aware of that. Another one is the experience modification rate, which again is a lagging indicator, which typically lags even more behind because it's usually for the previous year. And anything above a 1 is considered high risk. And so again, for a small company that has one large workman's comp claim, their EMR can spike up pretty high, which will put them out of contention for work with some of the larger companies. One of the things with the electronic record keeping that's that OSHA is doing now as well is it allows them to look at these things and be able to target inspections to companies that do have higher incident rates. All right, some of the leading indicators of safety, as I mentioned, those were both lagging indicators. Some of the things that you can look for to show that you are progressive and working towards continuous improvements with your safety is, one, making sure that you have good written programs, that those programs are reviewed at least annually, that you have a training program, one, to meet your minimum OSHA requirements for annual trainings, but also that is continuous training, that we're refreshing that we're staying up to date and providing different ways for different learning types, that we are qualifying our contractors that do work in our facilities. And again, using that those lagging indicators, but looking for these leading indicators when we're qualifying those people to do work. Using safety professionals. So have a full-time safety person on staff or a credentialed person. There's always room for improvements with that, and getting that training to anybody that has any involvement with your safety program. Third-party audits, again, as safety consultants, these are some of the things that we do is provide that additional service, even to people that have full-time safety person, manager, and a safety staff. We will still go in and do third-party audits on construction sites and general industry facilities, and it's a really good way to get that additional set of eyes to pick up on those things that might be missed. And again, you always have to remember that, we're talking about OSHA today and OSHA penalties and citations, but OSHA standards are the bare minimum. And if that's the only thing that you're striving for in a safety program, then you should probably be striving a little bit higher than that. So, right. So some of the things that we do have to report, which I believe I already mentioned, but any fatalities, they have to be reported within 8 hours. Severe injuries, so an inpatient hospitalization where somebody has to be admitted to the hospital, where they have a stay of at least 24 hours, they needs to be reported within 24 hours. And the other things that have to be reported would be amputation or loss of an eye. How do you report OSHA? You call the OSHA office, call the 1-800 number, and there's also you have the ability to report online through the OSHA website, which is osha.gov. Right. So on to OSHA inspections. Again, if we could poll the audience, if we were in person, I would ask if any of you have ever had an OSHA inspection, what your experience was with that. And we'll be happy to, if anybody wants to share anything that they've had, we can get that input towards the end of the presentation. But OSHA, when they go to work in the morning, how did they decide where they're going? And so some of the inspection priorities, the way that they pan out is an imminent danger situation is always going to take precedence over quality or a catastrophic accident. And I'll get asked, why is that the case? And that's because an imminent danger situation means if nothing's done, then somebody is going to die or be severely injured. And we can prevent that if they intervene in that imminent danger situation. Then their next priority would be things that are self-reported. So those fatality investigations or those catastrophic accidents of amputations, loss of an eye, inpatient hospitalizations. The next priority would be employee complaints and referrals. Again, we get, this is where we actually get some business from this when employees decide that they're disgruntled, and sometimes they make legitimate complaints that definitely should be followed up on by OSHA, but also sometimes a disgruntled employee will file an OSHA complaint as a form of retaliation. OSHA is required to follow up on every one of these complaints, be it in person or to send a letter, and the employer has to be able to explain any of the issues that were identified by that employee. High hazard industries would be the next target. And so again, with the electronic record keeping, it gives OSHA a way to look at to compare and contrast who has the higher incident rates and to target these companies for wall-to-wall inspections. Higher hazard industries would be construction, some of your larger manufacturing where there's large power presses. Anybody that uses powered industrial trucks would be considered a high hazard industry. And then finally, some of the special emphasis programs, these are found on the OSHA website. Each area, there are federal emphasis programs and so national federal emphasis programs and then local emphasis programs. These will vary and change over time, but some of the ones that we see consistently are powered industrial trucks, and they will, like I said, will change over time whenever there's a new standard issue. A lot of times you'll see special emphasis programs with silica was one that stayed on there for quite a while when the silica standards changed a few years back. This is, again, just as example of when you pull up the website, what you will see this was one that was current in 2019 that is still ongoing for falls in construction. And an OSHA inspector, when they are driving through town going, maybe they're doing a follow-up inspection. If they see something that is considered imminent danger, like somebody working at a height without fall protection or someone in an excavation without appropriate protection, they are required to stop and do an investigation, a follow-up on that hazard. So the current penalties, again, for a serious, other than serious type of violation is at $13,653 per violation. This does change. It has a cost of living increase that can be assessed annually. The most recent increase was last January, so we would expect to see another probably this January as well. One of the things that you have to know, the failure to abate, again, you can be charged that $13,653 per day until the item is abated, which can add up quite quickly. And then if you fall into a willful or repeat category, which is if you have an egregious issue that someone refuses to fix, or if OSHA comes and does a follow-up inspection within 2 years of the original citation, find the same issues, you can be charged that $136,000 per violation. There's a lot that goes into these calculations, and typically they will be reduced depending on whether they're corrected immediately, corrected on site, and depending on the number of employees, and several things go into calculating that. All right, so 2021 and moving forward, some of the things that we saw, during 2020, we were at the lowest number of inspectors working in a 49-year history. And so the inspections were down. As we started coming out of COVID, there were some of the offices that weren't doing any inspections. And they are back out there now doing inspections in person. And so we can expect to see the number of inspectors to continue to increase over the next few years. The budget you can see there, and again, it did increase over 2020, which means there's more, they're hiring more and having more people out there doing inspections. The penalties, again, will be predicted to continue to increase with that cost of living increase. And as we've seen, there's a emphasis on the COVID-19 programs, again, with the emergency temporary standard that's out. And we can direct you guys to some information on the OSHA website if you need information on that as well. All right. So we're going to talk a little bit now about handling an OSHA inspection, and again, how the process works and how to protect your rights. So the inspection process, OSHA will show up with no advanced knowledge. In some situations, you will have a heads up if you have reported an injury. Sometimes they will let you know a time that they're coming. If they're planning to do industrial hygiene monitoring, noise monitoring, air monitoring, they have to allow you time to set up for side-by-side monitoring. But in most circumstances, once they show up, you can ask them to wait until either your legal representation is there or your safety manager is there. Typically, you want to have someone there within an hour would be a reasonable time to make them wait. You want to make sure that the OSHA inspector is indeed an OSHA inspector. So they are required to show you their credentials. So they carry a badge, an official badge, and a business card, which is what they should hand you as they walk in the door. You want to make sure that they follow all the same safety protocols that you would have any visitor follow. Escort them into a comfortable area, have them wait, and get your highest member of management that's available to come talk to them. Right? Should you demand a warrant, or should you let them into your facility? It's a policy call. And again, if you're a larger company that has legal representation, it's something that you need to make a plan ahead of time to know what you're going to do. In most cases, I would say no. That's not something we recommend. You want to see what they're there for first, and they're going to do that in the opening conference, and they're going to let you know why they're there. It could be many reasons. It could be an employee complaint. It could be a special emphasis program, or any of those things that we talked about a few minutes ago. In that opening conference, OSHA is going to, the compliance officer is going to go through the purpose of the investigation, and usually have some written documentation that they're going to show you, and it's going to establish the scope of that investigation. You want to make sure that you ask for a copy of that complaint, and that's going to set the ground rules for the inspection. You don't want to volunteer information. So what a lot of people will do, oh, let me go immediately get you all of my safety plans and my training documents, and let me show you how great I'm doing out in my facility. So we don't want to do that. You want to give them exactly what they asked for. Treat them in a professional manner. Notify again your corporate officials and counsel if you have it, and then coordinate with any of your on-site contractors and vendors. If you use a third party, like we have an emergency app that our clients use to contact us, so it will locate our closest safety consultant to be able to come and walk a site with OSHA or help you guide you through the OSHA complaint. Does attitude matter? Absolutely. So the OSHA inspectors, these are all really nice people. I've never had any personality conflicts with any of these, any of the inspectors working with them on site. They're just there doing their job. But be honest, if they're there, they probably already know what's going on. And so you want to be honest with them, just treat them with a good attitude, and be willing to, if you don't understand why they're calling something out, ask them, and most of them will explain to you. Once you're involved in the walk around, the employer, you have the right to accompany the compliance officer, and you should. You should be prepared to take any photographs that they take, any corrections that you can make immediately when they identify them. You want to do that. You want to maintain control of the walkthrough. So again, limit the area that they see, and so you can walk them around to a side door that takes them directly to the piece of equipment or whatever it is they may be looking at. And again, just remember, if they're there to do industrial hygiene work, if they say, well, I want to, I want to put a noise monitor out for a few minutes or something like that, you do have the right to ask them to wait until you can set up for side-by-side monitoring for that. They will also perform interviews. I've seen, had clients where OSHA did 2 or 3 15-minute interviews where they asked a couple of people about, how they performed a lockout, what type of training they had. And then I've also seen an investigation go for 6 months where they interviewed every single employee, some of them for 8 hours. So it really just depends on the situation and why they're there. You want to have a comfortable place for those interviews to be performed. You also want to educate your hourly employees, but you can't really coach them what to say. You need to let them know that they do have the right to have someone with them. If they choose, they have the right to refuse the interview if they do not want to talk to the OSHA inspector, but they also do have the right to talk to them. And they are protected by the whistleblower rights, which is 11C of the OSH Act, which allows for no discrimination against someone for expressing safety concerns. Right. When management is in interviews, it is always okay to have another management personnel or counsel present. And so, again, if we always recommend, if it's an investigation involving a fatality, that you have your attorney present as well. OSHA will not allow you to tape record, video record, and they are way back in the technology. They bring a notebook and a pen and paper, and that's one of the reasons some of the interviews are quite lengthy, because you have to handwrite your statement and sign it. And just always remember, it's okay not to know. To say, I don't know, I don't remember, is always better than lying or guessing. Right, the actual inspection, they're going to ask for some certain documentation, and the best thing, if you didn't write it down, you didn't do it. So a good record keeping program, having some way to track the training that you do is a very good thing. And so the things that they're going to ask for is the OSHA logs, 3 to 5 years, copies of training that involve, if it was a powered inspection focused on powered industrial trucks, they're going to want to see your forklift training. They're going to want to see your daily inspections. They're going to want to see your written program. If it's something that requires monitoring, if you've ever done any noise monitoring for a hearing conservation program, or air monitoring, if you're working with something like silica or welding fumes, or things that they could request. If you're in an industry that requires medical surveillance, this could be your respiratory fit test, or your chest x-rays, or your blood test if you're working with lead. You have to provide them access to that. Their HIPAA rules still apply. So again, the names, any personal information can be taken out if necessary. Things that we don't recommend giving them is previous safety audits. And so again, like us as a third-party safety consultant, you don't want to say, hey, we have a third party, they do inspections all the time, let me go pull these for you, because you don't want to show them the things that you're doing wrong, but you can let them know that you do work with a third party. So the closing conference. So again, after OSHA does their inspection, they're going to do a closing conference with you on site to let you know any unsafe conditions that they've seen. They'll usually let you know if the corrections you made while they were on site are adequate, or if you're going to require additional corrections. You want to make sure that you take all of these notes. If you're not sure how to correct something that they've pointed out, ask them, what do you suggest? Can you provide me some information? They're going to go over your appeal rights. At this time, you don't want to argue with them or debate the issues that they've seen. The inspector that does the compliance officer that does the inspection, they are not going to issue citations then. They have 6 months for these to come back. They're going to be reviewed by the area director, who makes the final decision on what those penalties and citations will be. All right, once the citations come, they'll be in writing. We'll describe in detail what the issue is, what the penalty is. These citations have to be issued within 6 months of when the violation was discovered. There will be a proposed penalty. Again, sometimes they will come already with certain adjustments to those penalties and citations based on size or grouped. You need to post these for until they're abated, or for at least 3 days if you've already corrected, and they will come by certified mail. So again, sometimes with the mailing, if you get something and the abatement date has already passed, you just need to call them immediately, or it's in 2 days, and let them know that you need additional time, and just get that in writing. And so we talked about the dollar amounts with the penalties, and can you go to jail for OSHA violations? You can, in the event, it's very rare that these things get to criminal court, but they can. And again, that would ultimately usually only come into play if there was a willful violation that resulted in an employee death, or if you're falsifying records. So don't lie to OSHA. Right. So the next steps would be, we agree to pay the citations, we pay it, we're done, we move on. What we always recommend, even if you're ready to pay it, move on, is go to the informal conference. You have 15 days to schedule that, and you can either contest at that point, but at a minimum, go in, show them what you've done to correct it, what your plan is to make sure it doesn't happen again, and close it out. And a lot of times that goodwill, going in and doing that, showing them that you're putting your money into your safety program and you'd prefer to continue to do that instead of paying penalties, they will make a generous discount. And we typically see that with the clients that we represent with the when we go in for the informal conferences. You can press further if you want legally and go for a formal settlement, which is going to involve lawyers and courts and all of those good things, and a formal hearing. Again, with the formal hearing, it goes through the Health Review Commission. It's a formal complaint and answer. Just like in federal court, it goes through an administrative law judge, and they give a written opinion. Then it can be appealed and reviewed. All right. So now we're going to move into OSHA's top 10. Any questions so far? Okay. I'm going to keep on going. All right. So from 10 to 1. All right. The first one, and these in the previous slide is a hint as to what's coming here, our images. All right. So eye and face protection. And so that falls under our PPE standard. And depending on whether you're general industry or construction, It's a little bit different, but basically the same. OSHA does not tell us when we need eye and face protection. What they tell us is that we have to assess the hazards at our facilities and our job sites and determine when this personal protective equipment is needed. And so we should be going through a process of putting together a hazard assessment and then posting what personal protective equipment is going to be required. First looking at, and this one is based on the construction standard, and what happens when you go on a construction site is when you walk through the gate, there's usually a big poster on the gate that shows, I call him PPE man, and he has his hard hat, he has his glasses, whatever's required for that site, boots, safety vests, gloves, whatever it might be, and that's based on the hazards of that construction site. What OSHA can cite on is if they come into that site for whatever reason they're there and they see how PPE men's described, that's what we're supposed to wear, and they walk through the gates and nobody's wearing their hard hats, nobody's wearing their eye protection, then that is a potential citation. All right, number 9, machine guarding. In almost all the general industry citations I've seen over my career, there was a machine guarding element to those citations. And this can be as simple as a missing guard on a hand grinder, which I just settled a complaint with that, with a company that drops sinks out of concrete slabs, all the way up to our guarding around big robotic systems. And so the machine guarding is a very robust standard and something that you need to make sure that you continually audit any equipment that you have in your facility and that you maintain a good guarding program. Fall protection, and you'll see multiple top 10 things will typically relate into the fall protection, the standards specifically, or the training requirements. So again, not only are we required to provide fall protection equipment, but we have to train people on what those fall hazards are. And it varies per industry and what we're depending on what we're doing. But the basics for this one cited under the construction standard, which is the #1 way people die on a construction site, is through falls. And fall protection is required when we're working above 6 feet. And so again, if an OSHA inspector is passing by and can see your job site and people are working unprotected at heights, it's a very good chance that you're going to get a visit from that inspector. The powered industrial truck standard, and again, this is in the general industry standard. And again, we have tons of facilities, warehousing facilities that use powered industrial trucks. It's a very easy one to fall out of compliance with because you are required, every operator over that is required to have a license basically. So they go through a classroom training, a written exam, some type of knowledge assessment, and a practical familiarization with each piece of equipment that they operate. The operators are required to be over 18 and carry that license or that training card with them at all times. Many fatalities we see with powered industrial trucks, be that pedestrians getting struck by, loads getting dropped, people dumping them over, running off of docks. And so it is a very important one, and one that emphasis programs are typically in effect at all times for powered industrial trucks. Ladders in construction. So as I said previously, the #1 way people die on construction sites is falls. One of the things that they fall off of is ladders. And so this is one where people get cited. The #1 thing I see people doing wrong with ladders is using them inappropriately. So with a step ladder, they fold them up and lean them, or they don't secure an extension ladder properly, and then they twist and fall. So again, something we always want to make sure that they're in good condition. Anybody that's using ladders, that they are trained to inspect them daily and to get them off of your site or out of your facility if they're damaged. Respiratory protection. So respiratory protection is a pretty large standard. It's a horizontal standard which covers both general industry and construction, and it's one that can be easily misinterpreted. So again, as COVID came around, a lot of people that never knew what an N95 were learned what they were. And one of the things that I can say, you know, as we continue to go talk about COVID in the workplace, is you need to make sure that if you are mandating that your employees wear N95s as part of a COVID protection program, then you also have to implement a respiratory protection program because they are considered respirators. That respiratory protection program would include fit testing and medical evaluations for all of those employees. If you allow employees to wear them on a voluntary basis, then you don't have to do all of that, but there is some paperwork, Appendix D, that has to be signed and kept on file. With our general face coverings, if we get to the position where we have to require those or you're still requiring them, then that is not considered a respirator. Anything above and beyond the N95 with a tight fitting face piece, again, can be quite a tricky program because there is the medical eval, the fit test that has to be done annually. There's a training requirement, and we have to make sure that people are wearing the right types of respirators, the right types of cartridges, and receive the appropriate training. Control of hazardous energy. So this is our lockout tagout for general industry. Again, this standard combined with the machine guarding standard with almost all of the OSHA citations and penalties I've dealt with, and all the fatalities I've dealt with on the general industry side have involved typically removing a guard and failing to lock out those components. And so this, again, can be a complicated program, especially if you have a lot of different types of machinery, and that machinery has multiple energy sources. So we have to provide training, we have to provide a written program, we have to provide the right lockout tagout devices, and we have to maintain those, as well as specific procedures for each piece of equipment. It leaves a lot of room for error in the program, and if you get behind in your training and periodic inspections, a lot of areas where citations can occur. Scaffolding. So again, one of the things we always recommend if you're in construction that, again, if you are not a scaffolding company, that you make sure that you have a good one that is going to be able to, erect and dismantle your scaffolding. Some of the things that we see with scaffolding typically are failure to inspect it, mismatched components, lack of training, lack of fall protection above 10 feet. So lots of things that can go wrong with scaffolding. And so we want to make sure people are properly trained. All right, number 3 is also scaffolding. And then next to last, number 2 is hazard communication standard. And so in 2012, they made some standardizations to the HAZCOM program by bringing in GHS. When they did that, all the OSHA inspectors received a whole lot of training on HAZCOM, which made it one of the things that almost all the citations I've seen, general industry and construction, they typically will tack on a HAZCOM violation as well. These typically consist of no program, not having your safety data sheets, not having a chemical list, and probably the main thing I see is secondary containers being used, like when we pour something from a drum into a spray container and then not properly labeling it. So anything we put in a secondary container has to be labeled properly. And then finally, fall protection and construction. Remember, we had fall protection training, and I said it would be mentioned again. But again, the number 1 cause of fatality overall for people going to work is motor vehicle accidents. Number 2 and number 1 on the construction side is falls. And so fall protection is the number 1 thing that we see cited overall. And will continue to stay up there forever because we have people that are going to continue to build, and So it's just something we have to just make sure that we have a really good program. If we're supervising subs and subcontractors, that they have written fall protection plans, that they provide us proof that they've had proper training. And if we're responsible for our own teams, that they have the proper training and the proper equipment as well. All right. Right, so just kind of summing up, and again, this was from 2019. They lag behind, but it will be very similar. And you can see the ones in yellow are construction, the ones in white are general industry. But again, the HAZCOM is a horizontal standard, so that goes for both industries. Respiratory protection goes for both industries as well. All right. All right, so just a few takeaways. If you don't have a safety plan, no matter how small you are, it's a good idea to have some written procedures and to start that out. Again, OSHA doesn't necessarily require written safety plans for every topic, but it's a good idea. You have to have a plan, and work your plan is the best way to do that. Having a plan in place for your training and how you're going to accomplish that. For your documentation, you want to make sure you maintain inspections and training, and that's the two things to tell people that will keep you out of trouble with OSHA. If you can prove that even when something does happen, that the equipment was properly inspected and that the personnel had proper training, then you as an employer have done what you were supposed to do. And one of my pet peeves and one of the first safety talks I usually give all new clients is basic housekeeping. So you go to your facilities or your job sites, and if you just walk through and have people keep a tidy workplace, it's going to, number one, reduce your fire hazards. It's going to take away some of those things that we see common penalties for, like blocked emergency exits, blocked fire extinguishers, blocked anything that you may need, electrical panels, disconnects, those types of things. It's going to help reduce slip, trips, and fall hazards, which again, a number one thing that we see injuries in, and will also help, the clutter helps reduce those fire hazards. All right.
Before we wrap, I'm just curious. This is Doug. Given the craziness the last 18 months, how has that impacted OSHA's presence in the field? I know a lot of government agencies have not been, in their normal state of readiness. And
I just had this discussion with an inspector last week. I was sat in on a conference call, and they had their inspection during COVID. And the follow-up, I really didn't expect them to do a follow-up, but they did an in-person follow-up, and it has been about 10 months since the initial penalties came back. And he said that they were doing a lot of the informal conferences video, but he said they are back out. They are inspecting as normal.
Okay. And then the other thought was just, how you guys have a pretty big footprint and a lot of, different types of businesses. My practice is generally focused in construction, and we've been pretty impressed at, how little, direct most of our clients have felt from COVID, affecting their workforces. We've had a few delays, and we've had, definitely some illnesses and even in one or two fatalities out of tens of thousands of employees probably. But by and large, we feel pretty good about, a construction company's ability to manage that. Just in the nature of managing safety in general has been pretty good, I think. What have you observed over the last 18 months?
As far as COVID, the construction companies have done a very good job. The most part, the larger GCs of setting up, before the vaccinations were out, temperature checks, having, you don't think of construction sites as the cleanest place to work and having the best, washing facilities, but some of them went well above and beyond with setting up washing stations, providing that fresh water and temperature checks. And again, with the outdoor environment of most construction sites, I think the risk was a lot less than with some of your factories where we heard about, the bigger complaints were the manufacturing facilities where people were just, right beside each other. It's very hard to maintain that social distance. So.
Well, we very much appreciate you doing this program. Just want to reach out one last time. I mean, please, if you've got a question, sure, Katie will get that distributed after the program. But thanks very much for attending, and thank you for presenting, Shannon. This was great. With that, just being mindful of people's schedule, just want to thank everybody again. This is our last official program of the current year. And we got a number of things teed up for next year, but are always looking for fresh, topical, content of interest. So please reach out to me or to Katie and let us know if you've got thoughts about programs that maybe you want to hear again from the last several years, or something new that we would love to include in next year's lineup. So thanks very much. And with that, we'll close out the program.